calendar. It's my intention to go through the bills in order with the lowest number first and go through the bills. I accept a motion, and then we can have a discussion and hopefully get through as much as we possibly can today. I'd love it if we could get through all the bills that we currently have pending, and hopefully we'll be able to do that today. Unless there are any other business that we need to address now, then I will start our discussion this morning with House Bill 82.
Mr. Chair, you have to take attendance first, don't you?
Yes, I am sorry. I'm too anxious to get going.
I don't blame you.
And read the prepared script.
Yeah.
Yeah.
As chair of the House Judiciary Committee, I find that due to the state of emergency, declared by the governor, and as a result of the COVID-19 pandemic, and in accordance with House Rule 67 and the governor's emergency order number 12, pursuant to Executive Order 2020-04, this public body is authorized to meet electronically. This is a public hearing of bills referred to the Judiciary Committee. Executive session on pending legislation may be held. Please note that there is no physical location for members of the public to observe and listen contemporaneously to this meeting. However, in accordance with the emergency order, I am confirming that all members of the committee and select legislative staff have the ability to communicate contemporaneously during this meeting through the Zoom electronic meeting platform. And the public has access to contemporaneously listen and, if necessary, participate in this meeting by Zoom platform or by telephone. All necessary access information has been made available in the House calendar and through the electronic calendar on the General Court website. The notice for this meeting complies with House rules and RSA 91A, the right to know law. Anyone who has a problem accessing the meeting should call 271-3600. That's 271-3600, or email hcs@leg.state.nh.us. In the event the public is unable to access the meeting will be adjourned and rescheduled. We also have a staff member who will also be attending the meeting. That's Jennifer Ford, our committee researcher. Please note that all votes that are taken during this meeting will be done by roll call vote. We'll begin the meeting by taking roll call attendance. When each member states their presence, please also state whether there's anyone in the room with you during this meeting, which is required under the right to know law. I'll begin by saying, this is Ned Gordon. I am at the Legislative Office Building in room 206-208 with other committee members. And Mr. Clerk, would you take the roll?
Do the best I can, Mr. Chairman. Representative McLean.
Present here in the room.
Representative Sylvia.
And I'm getting there. It's Representative Sylvia in Belmont, Home Alone.
Representative Walker is here with three members. Representative Alexander.
I am here in Concord. Good morning.
Representative Rice. Representative Rice.
Oh, I'm sorry. I'm here. I can hardly hear you. I'm here at home alone.
Well, I just wanted to tell you. Representative Silver.
Representative Silver is absent today, and a substitute has been provided.
All right.
And the committee was.
Got it, but I can't get the video on.
The committee was provided with notice that he would be absent today, and that Representative Stephen Smith would be his substitute today.
Representative Smith.
Thank you. Present in room 206 and 8 in the yellow bib.
Representative Green.
here with my wife and Hudson. You are breaking up a lot. It is hard to hear you.
Representative Kelly.
I wasn't here and just got here. My internet went out 1 second before I sat down, but I'm back and I'm here alone in Temple.
Representative Tosh.
Hi, I'm here at my home in Merrimack alone.
Representative Trotter.
Good morning. I'm here at my home in Belmont in the office alone, but I do have children in the house.
Representative Smith.
I'm here in Durham in a house functioning on a generator because our power's out. And in another room in the house is another member of the committee.
Hello.
Representative Birch.
Good morning. I'm alone and I'm in West Milan, and we just got our electricity back a few minutes ago.
Representative Horrigan.
I am, I should unmute myself.
You are.
I'm Representative Oregon. I'm here alone at my home in Durham.
Representative DiLorenzo.
Good morning. I'm alone in my home in Newmarket, and there's no one else in the room.
Representative Chase. Representative Chase.
Looks like she dropped out.
Was she here?
She was here, but she looks like she dropped out.
Oh,
She's here, but she's muted, it looks like. There she is.
There she is. Oh, there we are.
Representative Chase. I'll come back.
Wendy,
Representative Kenny.
Thank you. Good morning. I am here in Durham. I am actually at Representative Smith's house in a different room. So thank you for having me, Representative Smith. And yeah, thank you.
Representative Langley.
I'm here in Manchester with my husband. I'm having trouble with my video, however, but I am here.
Representative Macbeth.
Good morning. Representative Macbeth is here in Portsmouth, alone in her home office. Thank you.
Representative Page.
Good morning. I'm alone in Exeter, home office. Thanks.
Representative Simpson.
Good morning. I'm here in Exeter alone right now. And my husband and sons are in the house and may come through at some point later in the day.
Representative Chase.
Good morning. Sorry about that. I am here home alone in Rollinsford.
I think the attendance 21-0.
Hey, everyone is here. Noting that one person does have a substitute today. And having taken the roll, we'll begin our session this morning. We'll go through the matters that we have pending today in order, and we'll begin with House Bill 82, an act relative to amending a conservation easement between the state and a landowner. Yes, Representative Sylvia.
I understand that Representative Birch has an amendment, but I would move ITL. I believe this involves a constitutional issue of contracts, and I don't think we can study our way out of that. But I'd move ITL if the chairman would accept it.
And there's a motion to recommend an expedient to legislate. Is that seconded by anyone? Oh, by Representative Alexander. And you want to address your motion, Representative Sylvia, more than you already have?
Right. This is a very complex issue, and essentially when you boil it down, these easements are contracts, and often contracts with people who have passed. And our Constitution, Part 1st, Article 2nd, supports the concept of contracts. And even if this is a simple study committee, I think it's a study committee with a dead end. And I believe that that's a little bit too much to overcome. So So that's where I'm going with the ITL.
Representative Birch?
Thank you. I obviously oppose that motion, and should that motion not succeed, I would be moving an amendment that narrows the scope of the study committee to the particular statute that's blocking a solution to this case and to some other similar easements. It seems like most of the parties agree that the situation with some very old easements under a very specific statute is working in injustice. And I would hope that this committee would take a stand in favor of the little guy, in favor of the citizen, in favor of the farmer, as opposed to government bureaucracies and the like. It's kind of a freedom issue for my friends across the aisle. Basically, the idea of looking at reforming a statute is what the legislature does. That is our business. And this study committee is supported by the Attorney General's office. The study committee is supported by the Commissioner of Agriculture, Sean Jasper, the head of the Charitable Trust Division came and told us that he felt this specific statute needed to be worked on. And I don't support too many study committees, but I'm even willing to be on the study committee as needs be. So I would urge this group to not vote to close our ears to the pleas of our small farmers and our citizens, reject the ITL so another motion can be made.
Representative Rice?
Thank you, Mr. Chairman. I would just say that we don't really need a bill to do a study committee. An ad hoc committee can be formed and it can be done. We don't need to formally create a study committee for this if it's that important.
And Representative Horrigan?
Thank you, Mr. Chair. I just like to humbly disagree with the member from Belmont's constitutional theory. In fact, if anything, regulating and enforcing contracts is one of the most important things the government does. The idea that we have no jurisdiction over contracts is not something that I would agree with. And then anyway, in this case, if there is indeed well, first of all, we're only dealing. There's only also. But if indeed there is a constitutional impediment to doing anything about these old easements, which were the impetus for the bill, study committee can get together a few times, and I think a formal study committee would have more stature, probably have a higher priority on the various experts' time. So if indeed there is a constitutional impediment to it, which I don't believe, a study committee is a good way to look into that. But I think the study committee has a much broader scope than that. So I think it's a very useful exercise. And so I think we should go forward with it. Thanks.
Representative McLean.
Representative Smith has hand up.
I'm sorry, Representative Smith.
Thank you. An inquiry of the chair, if I may. I realize I'm a visitor here, but I'm looking at the underlying bill and I'm confused by the debate because I don't see a study committee.
I think that if the ITL motion is defeated, Representative Birch intends to offer an amendment.
Thank you. Further inquiry?
Sure.
Without the amendment being actually moved, I'm unclear as to why we're debating it.
Yeah, I don't think I don't think the intention is to debate the amendment. I think it was offered by Representative Birch as his potential alternative. So, yes, Representative McLean.
Yeah, thank you, Mr. Chair. I agree with Representative Rice. I do think there is some inconsistency with some of the new easements and the old easements. So there's an opportunity here. If an amendment were to be offered, however, I don't think we need the committee. I would actually favor a motion of retention, and I think this is something that we could do within the committee ourselves. So that's what I would favor.
So as an alternative to the ITL, you'd be looking for retention.
I've been looking for retention as an alternative, but that's not the motion on the floor right now. So.
Okay, thank you. And Representative Rice, did you have your hand up?
I did. That was what I was going to say was, why can't we just retain it and work on it in the committee then rather than creating a study committee?
And Representative Birch?
If that's what happens, I can certainly live with that.
And Representative Alexander?
Thank you, Mr. Chair. I'm willing to withdraw my second so we can make a motion to retain.
Okay, you're withdrawing your second. And would you withdraw your motion, Representative Sylvia? You're muted.
Still muted.
Yes, multitasking. I will certainly withdraw my motion, assuming I will not be studying the retention. I still think it would be unconstitutional.
Okay, so Representative Sylvia has withdrawn his motion. Is there somebody who wants to make a motion to retain?
I'll make a motion to retain.
So Representative McLean makes a motion to retain.
I'll second that.
Representative Chase?
Well, whoops, a couple of things. I wanted to say if we do decide to do an internal study committee, I would like to be on that, and I would make that second motion if Representative Rice didn't yet.
So we have a motion to retain the bill currently. And is there any other discussion? Seeing none, if you vote yes, you'll be voting in favor of retaining the bill. If you vote no, you'll be voting against that. And Mr. Clerk, would you take the roll?
Thank you, Mr. Chairman. Retention of House Bill 82, Representative McLean.
Yes.
Representative Sylvia.
No. By the way, Representative McLean does not have video going.
But he's in the room.
Ah, okay. That I can't tell.
So I will just tell you that if I turn mine on, you would be getting so much feedback, and we've all had that issue. So I don't think anybody in here has their microphones on. You said no, right, Representative Sylvia?
I said no, correct.
The clerk votes yes. Representative Alexander?
Yes.
Representative Rice?
Yes.
Representative Smith?
Which one?
Oh, I'm sorry, Steve Smith?
Yes.
Representative Green?
Yes.
Representative Kelly? Representative Kelly?
Currently muted.
Yeah, that whole mute button thing is a pain. No.
Representative Tosh?
Yes.
Representative Trottier?
Yes.
Representative Marjorie Smith?
Yes.
Representative Birch?
Yes.
Representative Horrigan?
Yes.
Representative Di Lorenzo?
Yes.
Representative Chase?
Yes.
Representative Kenny?
Yes.
Representative Langley? Representative Langley? Still here?
She said they were having problems early with the internet, so I wonder if it went out.
All right. Just over here, not voting. That'll be interesting. Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
I have to vote as 18 yeas, 2 nays, and 1 not vote. Representative Langley, if you're here, you can still have a chance to vote. So 18 yay, 2 nay, 1 not voting.
We voted 18-2, and the bill will be retained in the committee. Next bill to be addressed is House Bill 83. There a motion on that? Representative Birch, do you want to make a motion?
Thank you. I would move OTP and also be moving a small amendment 0369H.
Well, he can address the amendment. What was the amendment number?
0369H.
And is there a second to that?
I second.
Thank you. If you want to address your motion, go ahead, Representative Birch.
Yes, as I indicated at an earlier hearing, the amendment makes it clear that this bill affects claims by or against a government unit. So we've covered it in both directions, basically, whether the government unit is a plaintiff or a defendant. We would not have secrecy along the lines of this bill. So it's a small amendment, but that's what it's been suggested, and I think it's a good idea.
Any other discussion? House Bill 83? Seeing none, are you ready to vote? Yep, we're voting on the amendment, which is 0369H.
Amendment 0369H to adopt. Representative McLean,
Yes.
Representative Sylvia,
Yes.
clerk votes yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
Yes.
Representative Birch,
Yes.
Representative Horgan,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
welcome back. Representative
Thank
McBeth,
you. Macbeth, yes?
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes?
votes 21-0.
Okay. That brings us to the motion as amended, the not to pass as amended motion. Is there any other discussion on that? That was seconded by- Okay, all those, and clerk will call the roll.
House Bill 83 ought to pass as amended with 0369H. Representative McLean,
Yes.
Representative Sylvia,
Yes.
the clerk votes yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
Yes.
Representative Birch,
Yes.
Representative Horgan, Representative Horgan,
Oh, no, I'm voting no, sorry, no.
Representative DiLorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
20 yeas, 1 nay.
Representative Horgan, you have any interest in doing a minority report?
Oh, no, that's okay. You can put it on consent too, as far as I'm concerned. So, no, I'm fine. I'm fine. Thanks.
So we are recommending ought to pass as amended in House Bill 83 and without objection will be placed on the consent calendar. Next bill is House Bill 108, an act relative to minutes and decisions in non-public sessions under the right to know law. And Representative McLean, you have a motion.
I make a motion ought to pass.
And is there a second? No, second. Seconded. Motion made by McLean, seconded by Representative Wolper. And you want to address your motion?
Oh, yeah, just quickly, I think that this is a minor burden. We've heard testimony in the past of a tendency to have sealed minutes accumulate over time, and there's really nothing that goes back and provides a review. This is a minor burden where you would go and as you decide to seal the minutes from non-public session, you keep a list. It'll just make it easier if you want to go back and do some cleanup or some periodic review of that to be able to do that. So I think it's a real gain for transparency with minor effort.
Any other discussion on House Bill 108? That being the case, clerk, I think you can call the roll.
Ought to pass on House Bill 108. Representative McLean,
Yes.
Representative Sylvia,
Yes.
Representative Wolper, yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Smith Stephen,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
Yes.
Representative Birch,
Yes.
Representative Horgan,
Yes.
Representative DiLorenzo,
Yes.
Representative Chase, Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
I have a 21-0, move consent.
There's no objection. This will be placed on the consent calendar. The next bill is House Bill 111, an act establishing a cause of action against the state to protect individual rights. Representative Burke, would you like to make a motion?
Sure. Thank you, Mr. Chair. I would move OTP.
Representative Burke moves ought to pass. Is there someone who would second that?
Second.
Seconded by Representative Simpson. And do you want to address your motion, Representative Burke?
I think we discussed it pretty thoroughly. I just appreciate that this is a bipartisan effort and wanted to acknowledge the work of Representative Lekas in assisting on this bill, as well as the Institute for Justice. Thank you.
Any other discussion? Seeing none, Mr. Clerk, can you call the roll on a motion of ought to pass?
Ought to pass on House Bill 111. Representative McLean,
Yes.
Representative Sylvia,
Yes.
the clerk votes yes. Representative Alexander,
No.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
No.
Representative Marjorie Smith,
Yes.
Representative Birch,
Yes.
Representative Horrigan,
Yes.
Representative DiLorenzo,
Yes.
Representative Jake,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson.
Yes.
Mr. Chairman, as orders 19-2.
Does anybody wish to do a minority report? And does anybody have an objection if it were to be placed on the consent calendar? Without objection, will be placed on the consent calendar. House Bill 124, an act adopting the Uniform Real Property Transfer on Death Act. I think I would like to make a motion, if I could, to retain that bill. It provides, I think, that's seconded by anyone?
I'll second it.
Seconded by Representative McLean. I think this provides a real opportunity for estate planning, and we heard the testimony that this is something that's been adopted in a number of other states, 30 other states, and will provide an effective estate planning tool for a lot of people who their only asset in life is their house, and they might want to be able to transfer it without having to do complex estate planning. But what I discovered after we had the hearing was that this has another impact, and that's an impact on our registry of deeds. Because traditionally in the registry of deeds, you either have a grantor or a grantee. In this particular case, you really don't have a grantee until the grantor dies. And this is going to require, although the bill seems simple in terms of what it's going to do between one person and another, it has some effect on government and how it operates. And I think that that needs to be studied and and addressed before we put this into effect. And I would just ask the committee if they would be willing to retain the bill so we can try to work that out before we legislation. Any other comments?
Mr. Chair, who seconded that?
Representative McLean.
Thank you.
Other discussion? If not, would you like to call the roll?
To retain House Bill 124, Representative McLean,
Yes.
Representative Sylvia,
Yes.
Mark votes yes. Representative Alexander,
Yes.
Representative Bryce,
Yes.
Representative Steve Smith, yes. Representative Green,
Yes.
Representative Kelly, Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
Yes.
Representative Birch,
Yes.
Representative Horrigan,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Chairman,
Yes.
21-0.
So about 21, nothing, we will retain the bill in committee. Next bill is House Bill 133, an act creating a cause of action for censorship by social media. Yes, Representative Sylvia.
I'll move ITL.
Is there a second for that?
I'll second that.
Seconded by Representative Bryce.
That was Representative Marjorie Smith. Sorry
Thank
about
you.
that.
Okay. Representative Sylvia, do you want to address your motion?
Sure, just briefly, this bill is really pretty unworkable. Essentially, it would, if it were able to be applied, it would restrict New Hampshire companies as opposed to perhaps the offenders that are more desired to be affected. So it just won't work.
Representative Horrigan?
Thank you, Mr. Chair. Well, there's a very fundamental First Amendment issue in that the First Amendment freedom of the press also covers the right not to use your press to publish material you find objectionable. And also the business model of these social networks is to provide people with content which they want to read, so they can leave out shadow banning, but that's pretty much what you do is they preferentially distribute things that lots of people want to see as opposed to stuff that nobody wants to see. And that's that's part of their fundamental business model. So the shadow banning, unfortunately, is part of it. Also, I think the barriers to entry are probably not quite as large as people think. These platforms come and go, so the ones that and there is like a free market incentive to be like as inclusive as possible. So I think this is and also of course this is a federal issue anyways. This is a bad bill, so I agree that it could be ITL. So thanks.
Any other discussion on House Bill 133? We have a motion pending for inexpedient to legislate. And Mr. Clerk, will you call the roll?
Inexpedient to legislate House Bill 124. Representative McLean,
Yes.
Representative Sylvia,
Yes.
clerk votes yes. Representative
No,
Alexander.
no, wait. Excuse me, we've already done 124. This is 133.
133.
Oh, I'm sorry.
Sorry.
All right, so next meeting, what's laid on vote, 133.
133.
Representative McLean,
Yes.
Representative Sylvia,
Still a yes.
clerk is still yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Troyer,
Yes.
Representative Marjorie Smith,
Yes,
Representative Burke,
Yes.
Representative Horgan,
Yes.
Representative Renzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
makes it a unanimous 0.
So we've adopted the recommended and expedient legislate
Move consent.
and without objection will be placed on the consent calendar. Next bill is House Bill 135, an act requiring parties responsible for pollution of a drinking water supply to be financially responsible for certain consequences of that pollution. Representative McLean, you have a motion.
Yes, thank you, Mr. Chair. Mr. Chair, I move ought to pass and offer amendment 0473.
And is there a second to that?
I would second that, Mr. Chair.
Seconded by Representative Chase. That's your motion.
Yeah, thank you, Mr. Chair. Even though Litchfield is in my district, I was not an original co-sponsor on this legislation. I think what changed my mind about this legislation is right after the election, I got a letter from Penachuk basically stating that they were filing a rate case with the PUC for an over 20% increase, for the people in Litchfield. And it really made me realize that although they had no involvement in bringing this to bear, they were going to be bearing the consequences of that for 10, 20, 30 years. And so I think that there is some merit to the legislation. There were concerns in the original legislation, as discussed by DES, really wanting to clarify the nature of the hookup, preferring that it be city water and that the standalone units be more a temporary thing until we could go in that direction. And also fears that the 5-year compensation would be a barrier to compliance. So what the amendment does is just basically clarifies that we want to go forward with the city hookup when possible, and it cuts the 5 years back to 2. And so that's basically the fundamental content of the amendment.
So we're actually, I think, addressing the amendment right now.
Correct.
And other discussion with regard to the amendment? Don't see it. Then I guess we'll be voting on the amendment as offered by Representative McLean. That's Amendment 0473. Mr. Clerk?
Adoption of Amendment 0473 to House Bill 135, Representative McLean,
Yes.
Representative Sylvia,
Yes.
clerk votes yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh, Representative Tosh,
I'm sorry. Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
Yes.
Representative Birch,
Yes.
Representative Horgan,
Yes.
Representative Horgan,
Oh, I thought I was unmuted. Yes, I vote yes.
Representative DiLorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
21-0, the amendment is adopted.
We adopted the amendment 21-0. So now we are back to the motion of ought to pass as amended. Sylvia.
Thank you, Mr. Chairman. The amendment makes this just slightly better, but I think the bill overall is not very well written. I think it puts people kind of at the mercy of the commissioner, as stated. So I don't think there's enough details in the language that sets out all of the remedies. So I'm going to be voting against the bill, although it's a great idea, but I don't think it really delivers what it ought to, like good water.
Thank you. Then McLean.
Thank you, Mr. Chair. I understand Representative Sylvia is concerned about the DES commissioner, but we did hear in testimony that there is a right of appeal to the Waste Management Council and then a further appeal available to the New Hampshire Supreme Court. So there is, in my opinion, still the preservation of due process with this bill.
Representative Wolper.
Thank you, Mr. Chairman. Mr. Chairman, I'm opposed to this bill, not because I don't have sympathy with the people, but because I don't think we should be introducing a new class of action into tort law. Tort law right now requires actual damages. This bill doesn't require any actual damages. It's all prospective. The potential penalties that will be paid are unlimited because the time frame for these things to work out might be unlimited, and the cost of compliance might be unlimited. So I can't support that at all. I mean, there you go.
Are you thinking, which bill are you
It's a
thinking?
medical monitoring bill, right?
No, this is not the medical monitoring bill.
I'm speaking to the wrong bill, Mr. Chairman.
Yes. So I just wanted to clarify that. This is a very clear, circumscribed remedy. This is just a water hookups, Representative Bolton. 135.
Representative Horgan.
Thank you.
Yes, as I understand this bill, well, it talks about consequences, the title, not damages. So the word does appear in the text of the bill. So I think the idea of this bill is to encourage all parties to take preventative action. So the polluters will have to take preventive action, and that should save them money in the long run and save the affected people all the suffering, because if you filter the water supply or otherwise mitigate it, and if you stop the pollution, then that's a better solution than just letting the pollution go unabated and no preventive action, and then people have to suffer the damages and then go through the whole court process. So I think this is good because it makes the problem prevents a big problem from becoming huge. So so I think this is a preventative this encourages preventive measures. So I think that makes it a very good bill. Thanks.
Any other discussion? If not, Mr. Clerk, the motion is not to pass with the amendment. And Mr. Clerk, can you take the roll? This is House Bill 135.
House Bill 135, ought to pass an amendment 0473. Representative McLean.
Yes.
Representative Sylvia.
No.
Clerk votes no. Representative Alexander.
No.
Representative Rice.
No.
Representative Steve Smith.
No.
Representative Green.
No.
Representative Kelly.
No.
Representative Tosh.
Yes.
Representative Trottier.
No.
Representative Marjorie Smith.
Yes.
Representative Birch.
Yes.
Representative Horrigan.
Yes.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman.
No.
I vote 12 and three of 9 in the negative.
Okay, you've adopted the motion, a recommendation about to pass as amended.
Is that 11 to 9?
Minority report?
Can someone repeat what the vote was? I couldn't understand him.
Right. It's 12 to 9 in favor of ought to pass as amended. And again,
Minority. Yes.
there will be is that going to be you, Representative Sylvia?
Apparently.
Okay, the next bill is House Bill 160, an act relative to notice of rent increases in certain residential rental property. Is there a motion from Representative Sylvia?
Yes, I move ITL.
And is that seconded by anyone? Joe Alexander, Representative Alexander, excuse me. And you want to address your motion, Representative Sylvia?
Certainly. While we don't call this rent control, it is rent control. It's got to start somewhere. And the first place to start is dictating terms of renewals of lease. So this is step one. If we can go this far, we can continue on down the line. I think the system as we have it now is, well, it's not exactly great. It causes rents to be higher. This would just increase that problem. And when we have an affordable housing issue, these sorts of things do not help. So that's where I'm at.
Thank you. Representative Kenny?
Thank you, Mr. Chairman. So I am speaking against the ITL motion. In my opinion, this is in no way, shape, or form rent control. All it is rent notification. It's a very simple bill. If a landlord can absolutely increase rent as much as he or she sees fit, just with the requirement of adequate notification. I think that saying the system isn't great is an understatement. throughout my 2 terms, we heard enough personal testimony and from others of people whose rent increased astronomical amounts with only having 30 days to either find that amount of money or another place to live. I think that we absolutely need to give Granite Staters more time. I believe that this bill is fair, 60 days that exceeds 5% or 90 days that exceeds 8% or more. So I think it's a very fair bill, and I urge my colleagues to vote this motion down so another one can be offered. Thank you, Mr. Chairman.
Representative Alexander.
Thank you, Mr. Chair. I just want to echo Representative Sylvia's points. This is, I believe, a step towards rent control. I believe the 30 days is adequate amount for notice. While I'm sympathetic and an advocate for more housing and the housing crisis, I believe that the solution to that is on the supply side and not further regulation on our landlords who are already experiencing huge amounts of regulations, especially during the COVID pandemic. So we need to vote this down. Thank you, Mr. Chair.
And Representative Horgan.
Thank you very much, Mr. Chair. I'll just say that the rental housing market here in New Hampshire is very, very different from what we learned in Econ 101. So the supply and demand curves are not like neatly crossing each other at a 45-degree angle. So I think this is not rent control, and it's certainly very far back from what was instituted in New York City 75 years ago, and which doesn't really exist anymore. So I think we need at least some sort of control over it, and this is just a very, very basic thing which lets the tenant know what the cost is going to be, because this is very, very different from an ideal market. The 2 sides of the market there's a severe shortage of rental housing, and there's also a severe power imbalance between the 2 sides. And you certainly see this is one of many areas where how they approach commercial leases is totally different. And part of the reason for that is, well, first of all, there's not a shortage of commercial housing, but also the players are, they're playing against people their own size. In that case, the tenants have as much power as the landlord, sometimes more. So this is just a simple thing to level the playing field. This is a residential housing market is not like what we have in Econ 101, and the whole issue of supply, that's a whole separate issue, which is beyond the scope of this bill, and that's really beyond the scope of this committee. But I don't think ITLing this bill is going to make anybody rush out and build more rental housing. So I'm going to vote against the ITL and hopefully get past the bill. Thanks.
Thank you, Representative Wolper.
Thank you, Mr. Chairman. Mr. Chairman, one thing we've heard loud and clear is that the rental market is tight and expensive, mostly because of regulations. And every regulation that we add increases the cost, decreases the availability, and makes the housing crisis worse. So I'm in opposition to this bill.
Any other discussion? Seeing none, ask the clerk to call the roll on House Bill 160. This is on a motion of inexpedient to legislate.
Inexpedient to legislate House Bill 160. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Rice.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
No.
Representative Burge.
No.
Representative Horgan.
Representative Horgan votes no.
Representative Di Lorenzo.
No.
Representative Chase.
No. No.
Representative Kenny.
No.
Representative Langley.
No.
Representative Macbeth.
No.
Representative Payton.
No.
Representative Simpson.
No.
Mr. Chairman.
Yes.
11 yeas, 10 nays.
The motion for inexpedient to legislate passes 11 to 10. And Representative Kenny, would you like to do a minority report?
Yes, please, Mr. Chairman.
Thank you.
Representative Kenny, that motion will be on to pass.
Yes.
Thank you.
House Bill 206, an act relative to collective bargaining agreement strategy discussions under the right to know law. For a motion, Representative Wolford, did you have a motion on that?
Okay, Mr. Chairman.
Representative Wolford moves on to pass. And is there a second to that?
I'll second.
Seconded by Representative Sylvia. You want to address your motion?
So I sponsored a bill just about identical to this last year. It's my opinion that we are the owners of what happens during collective bargaining. No matter which side wins or loses, the taxpayer pays. The taxpayer should know, be able to see what's going on during these negotiations. So I was appalled when my school board chairman, and I was having dinner at my church one night, and I asked him, he said, "Oh, I can't talk to you about what we're negotiating. I can't tell you anything about what was said." I said, "What do you mean?" Well, it's excluded because we're doing in the darkness negotiation. And now it's fall. So I think it's a great bill. It's transparent. It's in effect in many states. Some states have partial open, and a lot of states have totally open, as this bill asks for. Protected to give the boards an opportunity to develop their strategies and whatever in private. But when it comes to the actual negotiations, that should be in public. And we've heard from people who have been involved in national negotiations that this just isn't a problem when that occurs. Good bill.
Representative Macbeth.
Thank you, Mr. Chair. Despite my respect for the prime sponsor and my colleagues, I can't support the motion ought to pass. I understand that this bill, the intent is to create transparency, although I feel like it really will do the opposite, and it'll be detrimental to the collective bargaining process. And because I think it's going to increase, maybe create some posturing and a lack of candor. So I urge my colleagues to vote against the ought to pass motion. Thank you.
Anyone else wish to weigh in? Seeing no one, we do have a motion to make the recommendation of ought to pass. And Mr. Clerk, can you call the roll?
Ought to pass on House Bill 206. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Rice.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
No.
Representative Birch.
No.
Representative Horn.
No.
Representative Diorenzo.
No.
Representative Chase.
No.
Representative Kenny.
No.
Representative Langley.
No.
Representative Macbeth.
No.
Representative Page.
No.
Representative Simpson.
No.
Mr. Chairman.
Yes.
I have the orders 11 to 10. Pass.
Representative Macbeth, are you interested in doing a minority report?
Yes, I will on ought to pass. I mean on ITL. Apologize. Thank you.
Okay,
Just making sure you're on your toes.
thank you. I really appreciate that. House Bill 212, an act relative to drug courts and alternative drug offender grant programs. Is there someone who would like to make a motion on that? Representative Di Lorenzo.
Thank you, Mr. Chair. I'd like to make a motion of ITL on this bill.
And is there a second on that?
I'll second it.
Is that Representative Rice that made the second?
Macbeth.
Representative Macbeth made the second. Okay, and would you like to address that, Representative Di Lorenzo?
Yes, Mr. Chairman, thank you. This bill is unnecessary. The drug court program already provides for the services mentioned in this bill. So it allows the offender to participate in social work and mental health consultations already. And we heard testimony from Judge Nario that the services are already available for 18 to 24 months while the person is in the program. And the bill is well intended, but we need to also think about the cost of the bill. Right now, the present drug court is able to bill the participants' medical insurance, and medical insurance covers about 90% of the cost of the program. So that's why I vote ITL. Thank you.
Thank you. Any other discussion? Seeing none, I think, Mr. Clerk, can call the roll. This is on House Bill 212, and the motion is inexpedient to legislate.
Inexpedient to legislate, House Bill 212. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Rice.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter. Representative Trotter.
Yes. Yes.
Representative Marjorie Smith.
Yes.
Representative Birch.
Yes.
Representative Horgan votes yes.
Representative Rizzo.
Yes.
Representative Chase. Representative Chase.
Sorry, yes.
Representative Denny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman.
Yes.
As the vote is 41 to nothing, with consent.
Without objection, will be placed on the consent calendar.
Mr.
The recommendation of inexpedient to legislate. House Bill 216, an act relative to public notice of and access to meetings of the right to know.
I think Representative Smith had a question.
Oh, I'm sorry.
Thank you, Mr. Chair. I do have a question about this bill. As the news has been percolating through the legislature that the Speaker is working on adjusting our calendar and changing deadlines so that we can compact a time when we'll all be together closer to the end of March and the beginning of April. Because of that, the immediate urgency to vote on bills is somewhat lessened. We have an amendment that has not yet come back from OLS on this bill. So I wonder if you would consider just delaying this and to put it perhaps on the calendar for next week when we will be again executing bills. And that I don't think would add an undue burden since it's only 10:12 and we've already taken 12 votes. So we're moving right along.
Are you talking about House Bill 216?
That's what I'm talking about.
Does anybody have any objection if we hold that to our next executive session? We are planning to have an executive session next Wednesday, a week from this Wednesday.
Recess next week.
Why don't we'll hold off acting on House Bill 216 in order to afford Representative Smith the opportunity to get her amendment together, and we'll act on it. Plan to act on it next Wednesday.
Thank you for your courtesy, Mr. Chair.
Thank you. House Bill 227, an act relative to termination of tenancy at the expiration of the tenancy or lease term. And I would make a motion of ought to pass, and would offer an amendment. There a second to that?
I'll second that.
Seconded by Representative McLean. It's amendment 2021-0361H. First of all, I just want to say that if I've made any representations with regard to Elliott Berry supporting the bill, I'm completely inaccurate. I did believe that Elliott supported or did not object to the amendment that was proposed, but he has never supported the bill. And to the extent that the amendment would amend the bill, he wouldn't support that as well. He's my good friend. I just want to make it clear that I'm not speaking for him at all. So what this bill does is indicate that if you are a landlord and you enter into a lease agreement, that you would be able to terminate the lease at the end of the term of the lease without having to show that there was good cause other than the fact that the lease expired. And that makes sense because a lease is in fact a contract, and when you enter into that contract, you are only agreeing, the landlord and the tenant are only agreeing that they would have possession, the tenant would have possession of that property for the term of the lease. And in many cases, there is good reason, good cause for people to expect people to leave at the end of the term of the lease. But under current law, it just doesn't apply. So you may decide that you want to rent your property on Newfound Lake and you want to do it for a year, but then you have other plans at the end of the year. Right now, just signing a lease and saying your term is a year isn't sufficient. In order for that to ask that person to leave at the end of the year, you have to show that there's other good cause other than the lease expired. So it makes sense, I believe, to enforce the terms of the contract. I think that was the sponsor's intent. I think it has some unintended consequence, and that is it's very common for landlords to enter into a one-year lease and then allow people to hold over. So you may have somebody that enters into a one-year lease, the lease isn't renewed, and they're there for 6 years. Well, if that's the case, the way that the original bill is written, somebody can just terminate the lease at the end of, terminate the lease anytime, because the term of the lease is expired. So 6 years later, you wouldn't have to show cause. You could just terminate the lease. And I don't think that's fair, certainly not fair. So what the amendment does is say, yeah, you can terminate the lease, but you have to do it. You have to provide notice to the tenant before the lease term expires. So if you enter into a one-year lease, you would have to give the tenant 30 days notice in advance that you're not going to renew the lease and that you would like them to vacate the premises. And I think that is reasonable, a reasonable expectation, and I think it makes the bill certainly more acceptable to me. And so I would encourage people to support the amendment, because the amendment makes the bill better in any event, regardless of how you feel for the bill. But I would also ask you to support the underlying issues. Representative Macbeth.
Thank you, Mr. Chair, for the question. Just to clarify the details of the amendment, I understand that the landlord would have to give the 30-day notice for vacating the unit. Then after that 12-year mark, would it just continue at a 30 days, or would it be extend for another year and then the 30 days would start again? Or is it just on a month by month after that initial lease period?
No, well, if you enter into the written lease, basically, if you don't renew the lease, then all bets are off. Then you have to go back and you have to prove good cause for eviction. So and this I think the amendment will have a positive effect, because right now, so many landlords, very professional landlords, have people renew their lease every year, do a new written lease, renew every year. But the fact is that lots of landlords aren't professional landlords, and what they do is a one-year lease. It's very typical to do a one-year lease, and then that's it. And then the tenant just stays there because the tenant is proven to be a good tenant and they want them to stay there. I think if you put this amendment into effect, it'll have the effect of encouraging landlords to renew their lease every year, which is a much better practice, and a much better practice for everyone. But the fact is, if you let your lease expire, the lease term expire, then after that, you have to prove good cause. There's no automatic renewal. I hope that answers your question.
I'm sorry, I had a stuck mouth. Thank you very much for your response. Appreciate it.
Representative Di Lorenzo.
Thank you, Mr. Chair. I have a question for you. So once the 30-day notice is sent to the tenant, does the landlord then have to take the tenant to court to evict them?
I think thank you. That's a really good question and a very good point, because you still have to go, there's no, you don't just kick somebody out. They still have to take them to court. So if they don't leave the premises at the end of the lease period, they still have to go through the normal eviction process. And that's what the whole issue is about, and that is what standard is the court going to apply. And in this particular case, this would change the law to say that if you have a fixed term on your lease, a landlord gets to evict a tenant at the end of the term of that lease. And it makes a lot of sense, because people enter into agreements and they enter into the lease, and then they find out their tenant is a lousy tenant, frankly. They don't keep the place clean. I can tell you as a judge, you hear these stories all the time about they have a non-smoking apartment and the people are smoking in it, but they can never catch them smoking in it, but they know they are because of the smell in it, and they want them out at the end of the lease term. And it makes sense to give them the opportunity if they have a defined lease in order to be able to get them out. But then you go to court, and at court, you still have to prove that it's the end of the lease term and that you have a right to have them out. And then the court has discretion to give the tenants up to 90 days in order to vacate the premises. And it's very typical for judges to give a reasonable period of time, not uncommon for 30 days for people to vacate, even after the lease is expired.
Thank you.
Questions? Want to vote on the amendment? We call it roll. This is on the amendment. It's Amendment 03618.
So adopt amendment 03618 to House Bill 227, Representative McLean,
Yes.
Representative Sylvia,
Yes.
Representative Walker votes yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
No.
Representative Burke,
No.
Representative Horgan,
No.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
No.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
order 17. Vote 17-4.
17-4, we've adopted the amendment, and now, unless there's some discussion, call the roll on the bill about to pass as amended.
House Bill 227, amended by Amendment 03618, to pass as amended. Representative McLean,
Yes.
Representative Sylvia,
Yes.
Representative Ford votes yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Trotter,
Yes.
Representative Marjorie Smith,
No.
Representative Burke,
No.
Representative Horgan,
No.
Representative Di Lorenzo,
No.
Representative Chase,
No.
Representative Kenny,
No.
Representative Langley,
No.
Representative Macbeth,
Yes.
Representative Page,
No.
Representative Simpson,
No.
Mr. Chairman,
Yes.
I have to put it 12 in the affirmative, 9 in the negative.
Say that was order again.
12 to 9.
12-9, so we adopted the recommendation of ought to pass as amended. Is there going to be a minority report?
Could we get back to you on that a little later, Mr. Chair? Today.
Okay.
Thank you.
I do want to make sure that everybody gets their reports in tomorrow, by tomorrow sometime. Gets their emails into me by tomorrow sometime. So I can put them together, report them out. House Bill 236, an act creating a statute of limitation on civil actions relative to damage caused by PFAS substances. And is there a motion? Representative McLean.
Yes, thank you, Mr. Chair. I make a motion of expedient to legislate.
I'll second. Sylvia.
Representative McLean is moved inexpedient to legislate, and that's seconded by Representative Sylvia. You want to address your motion?
Yeah, thank you, Mr. Chair. I have a lot of sympathy for the concerns around PFAS, but I think that the 3 years is adequate, especially given the fact that this bill really doesn't change the time at which the clock starts ticking, which is at the point of reasonable discovery. So even if you're 20 or 25 years out, or if there's new information brought to bear that would alter that, then the clock basically starts again, because that's when this new information is discovered. So I really don't see the need. And in addition, what it does is it creates a special carve out for PFAS itself. And so I think as we go down the road and we discover other substances, I just see a creation of a patchwork in the future where we're going to be coming back, let's add this, and it's going to be this much and that much. So I think really, for me, the central point is the clock starts ticking at the point of reasonable discovery. That's unchanged. I don't think this bill is necessary, and I'm recommending ITL.
Yes, Representative Page.
Thank you, Mr. Chair. I would oppose the motion for ITL for a number of reasons. I think this is a law that catches up with the science. As we know, the law moves slowly. I think this is particularly relevant in this case because we know how difficult it is to prove toxic tort cases, as we heard testimony on that point. I think in terms of the carve-out issue, this makes sense with PFAS because this is in a suite of emerging contaminants. These are things that the science is learning about. In the context of PFAS, these are the negative health effects such as low infant birth weights, asthma, increased cancer rates, and they're particularly impactful on children, are latent to develop. So it makes sense that we would extend the normal, we would consider a typical normal statute of limitations on a negligence claim of 3 years to 6 years, given what we now know by way of science with respect to the PFAS chemical. The causal element still remains, so these are difficult cases to win. So it's not an easy win, but I think this recognizes a particular problem that we have in New Hampshire with a particular chemical that is particularly problematic. So thank you, and I would oppose the ITL. Thank you.
Representative Horgan.
Basically, well, Brendan Page probably said exactly what I wanted to say, but I just want to say a carve out for this is entirely justifiable because we have what frankly is a crisis, and these cases are going to be very difficult to prove. So I think the carve out is appropriate, and the extra time periods are appropriate just because they're so pervasive. In many cases, the polluters are very powerful corporations who are very good at defending themselves, and the consequences are for those who suffer the damages are very serious. So I think this is I think this bill is a small first step to, once again, as I cliche I used before, which is leveling the playing field. So I think a carve out to this is entirely justifiable. So that's why I'm voting against the ITL.
Any other discussion on the motion? Seeing none, we do have a motion pending. It's for inexpedient to legislate. Mr. Clerk, do you want to call the roll on that?
Inexpedient to legislate House Bill 236, Representative McLean,
Yes.
Representative Sylvia,
Yes.
clerk votes yes. Representative Alexander,
Yes.
Representative Rice,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Todd,
No.
Representative Trotter,
Yes.
Representative Marjorie Smith,
No.
Representative Garrett,
No.
Representative Horgan,
No.
Representative Di Lorenzo,
No.
Representative Chase,
No.
Representative Kenny,
No.
Representative Langley,
No.
Representative Macbeth,
No.
Representative Page,
No.
Representative Simpson,
No.
Mr. Chairman.
Yes.
10 in the affirmative, 11 in the negative. Motion fails.
The motion has been defeated. Is there another motion? Representative Page.
Yes, I'd make a motion to ought to pass, and I won't elaborate more on the points that I already made with regard to opposing the ITL. So I think all of those, the time has come, I think, for the science to catch up. A lot to catch up to the science, as I said before. I think this makes sense in the context of New Hampshire. We heard plenty of testimony about the impact of PFAS here, and I think it's time for passage. And I would vote to ought to pass.
And who's seconding that?
I'll second that.
Representative Chase is seconding. Is there any other discussion? Seeing none, Mr. Clerk, you can call the roll. This is on the motion about to pass.
Ought to pass on House Bill 236. Representative McLean,
No.
Representative Sylvia,
No.
First votes no. Representative Alexander.
No.
Representative Rice,
No.
Representative Steve Smith,
No.
Representative Paul Green,
No.
Representative Kelly,
No.
Representative Frost,
Yes.
Representative Trotter,
No.
Representative Marjorie Smith,
Yes.
Representative Burke,
Yes.
Representative Horgan,
Representative Horgan votes yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
No.
by 11 to 10,
You've adopted the recommendation of ought to pass by a vote of 11 to 10. Going to be a minority report.
Yes, Mr. Chair.
Representative McLean.
Mr. Chair, I'm sorry, I didn't hear anything you said.
Yes, the ought to pass motion was adopted 11 to 10.
Thank you.
And Representative McLean is going to do a minority report.
Okay, thank you.
House Bill 287, an act relative to remote notarization. Representative McLean.
Thank you, Mr. Chair. I would make a motion of the retention on this bill.
Is that seconded by anybody? Seconded by Representative Alexander.
I think there's some merit to the bill, but the Mortgage Bankers Association mentioned in testimony that the Senate was working on something comparable, and so they were developing some language there. So I think if we retain it, it gives us an opportunity to see the product that the Senate generates and gives us some flexibility to move in the future.
Representative Macbeth?
Thank you, Mr. Chair. I would agree and with my colleagues that comments, and I support the retention of this bill. Thank you.
Any other comments or questions? Seeing none, Mr. Clerk, will you call a roll on House Bill 287? This is on a motion to retain in committee.
To retain House Bill 287, Representative Spain,
Yes.
Representative Sylvia,
Yes.
Clerk votes yes. Representative Alexander,
Yes.
Representative Bryce,
Yes.
Representative Steve Smith,
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Fraudier,
Yes.
Representative Marjorie Smith,
Yes.
Representative Burke,
Yes.
Representative Horgan,
Yes.
Representative Rizzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Chairman,
Yes,
received by 21 unanimously.
we have voted to retain House Bill 287 in committee.
That's 5 minutes to get some.
Well, yeah, I think the clerk has to renew his forms for one thing, but we've been going for an hour and a half, and if we could take about 10 or 15 minutes for everybody to get rid of their morning coffee, that would be great. Thank you.
Thank you.
You know this?
Ugh.
Mr. Chair, what time do we reconvene? You said 10 or 15, so I'm just wondering.
Yeah, well,
I can't hear things.
why don't we make it 5 up? Okay,
Copy machine.
5 up.
The copy.
So I can put these on here, and make more.
Did you find that email?
Jennifer,
I
can you
did.
hear me?
Yep, I got it up.
Oh, good.
Jen?
Can hear you, yes.
Do you have more of these forms?
Which form do you need? The exec sheet?
I need one more roll call sheets and some more executive session.
Okay, I'll get those for you and bring them down.
Thank you.
You also
You're
have
welcome.
Representative Alexander as a co-host.
We got these.
All right, okay, there you go. Sec. Roll call.
All right, everybody. Unmute.
And needs to take care of the. Okay, Jen, we can take down the recess screen.
You have all your paper, Kurt?
I have enough for a couple of bills. I can go on here, electronic files, and I can do it that way.
Hey, Jen, are you?
It just takes one.
So
Are you there?
is she just coming down to give it to you?
She said she'd bring it down.
She may be walking down to give him his papers.
Welcome. See, she's there. Let's say a minute and a half.
She got stuck in the elevator. That happened to me this morning.
I know it did.
That's nice.
Is it? But it wasn't long, right?
10 or 15 minutes.
You were stuck 10 or 15 minutes?
I don't know about you guys, but I'm fairly certain my house is going to blow down in the next minute or two.
Yeah, I've actually had power been flickering off and on during our break. So hopefully I've been stable now for the last 5 minutes. So hopefully,
Yeah.
good.
She's on the way back.
We're just waiting for Jen to take down our recess screen and we'll get to it.
I did send everyone the hopefully final amendment for HB 540. If you can pull that out regarding the language in the bill.
Okay, we'll call this meeting of the House Judiciary Committee back to order. Our next bill to address this morning is House Bill 360, an act relative to rental of shared living facilities. And I would offer, I guess I will make a motion of ought to pass
Second,
and offer an amendment. And is that seconded?
to three. Yes. Are we on 360?
We are.
Okay. Yes, I'll second your motion.
The amendment is 2021-0513H. We heard this bill. This is with regard to shared living facilities, and there were questions raised as to whether or not it needed more specific definition. This amendment came from Elliot Berry, actually. He's the one who raised the issue in the hearing. And he proposed this amendment, which he represented to me in his email. He had reviewed with Mr. Norman as well, and they were in agreement on the amendment. And what it does is require that the tenant identify in the petition, petition that's filed under 540B, that there be a checkbox on the circuit court's form petition that the rental unit is governed by 540B, which is in fact the shared living facilities law, and not under 540A, which is for the general tenancy law. Yes, Representative Smith.
Thank you very much, Mr. Chair. Can you give me either your legislative or your judicial advice? That's up to you. Does this amendment address effectively the need or the need for a definition of what these facilities are?
I don't believe it provides a definition of the facilities. I don't know, without going back and looking in the statute, as to whether or not they're further defined in the statute, Representative Smith.
Oh, Mr. Chair, that's a disappointing response, because my concern is there seems to be so much confusion around what exactly a shared facility is. And I see that this amendment does attempt to clarify which specific section, which specific RSA is relevant. And I guess I just need assurance that it is enough specificity so that we're not making things more confusing than necessary.
I'm not sure I can give you that specificity.
I'm sorry, I didn't hear you.
I'm not sure I can give you that specificity.
Thank you.
Familiar enough with it, Representative Smith.
Thank you.
It's Representative Macbeth.
Thank you, Mr. Chair. So I just want to share my colleague's opinion. I felt favorably about the testimony, but I couldn't believe it. I mean, I'd never heard of this type of living situation, and we don't have it here in Portsmouth. So, and when I think there was a question about it, and she's like, well, everybody knows what it is. It's like, no, I don't know what it is. And then so could we possibly retain this to make sure that we have a definition of what exactly we're talking about? You know, what type of living situation this is? Thank you.
Frankly, I'd be perfectly happy with retaining the bill. So.
I'm sorry, I meant, excuse me, if I could follow up.
Yep.
I meant if we could even hold it until, if we're going to hold any bills, maybe we could hold this one so that we could check on that definition or add it to it. Because it seems like a narrow group of people that if we could help them, I don't have a problem with that. So I didn't mean retain. We could just recess this part executive session and pick it up next week after the questions are answered. I'll defer to the chair.
Thank you. Representative Simpson.
Thank you. Thank you, Mr. Chair. I was just wondering if it'd be helpful at all if I read the definition from 540B and people can hear if it sounds, would that be helpful?
That would be helpful. Yes, please.
A shared facility means real property rented for residential purposes, which has separate sleeping areas for each occupant, and in which each occupant has access to and shares with the owner of the facility one or more significant portions of the facility in common, such as kitchen, dining area, bathroom, or bathing area, for which the occupant has no rented right of sole personal use. And then there are several exclusions. A shared facility shall not include facilities rented to transient guests intended for use of less than 90 days, rooms in hotels, motels, inns, tourist homes, and other dwellings rented for recreational or vacationing use, rooms provided ancillary to other primary purposes such as jails, dorms, student dorms, nursing homes, hospitals, group homes, and emergency shelters.
Thanks.
Yeah.
Does that help Representative Beth with your question?
Absolutely. I'm sorry I didn't think about reading the statute. We know how important that is, don't we? Thank you so much, Representative Simpson.
Thank you. Representative Alexander.
Thank you, Mr. Chair. I think Representative Simpson did a great job in actually reading the statute, and I think that this bill is pretty straightforward with the amendment, and I think we should pass it.
Thank you. And Representative Smith?
Thank you. I agree. That does give us enough specificity. And of course, as we note, the amendment requires the specific RSA citation. So I appreciate that. Thank you.
Thank you, Representative Simpson. Is there any other discussion? Well, we have the motion pending and on the amendment first. So if there is no other discussion, we'll take a vote on the amendment.
To adopt amendment 0513H to House Bill 360. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Votes yes. Representative Alexander.
Yes.
Representative Rice.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Sardier.
Yes.
Representative Marjorie Smith.
Yes.
Representative Burt.
Yes.
Representative Horrigan.
Yes.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Best.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes, and for the record, that was my son trying to get my attention before the vote and not a nefarious actor, if you saw or heard that.
Unanimous 21-0 vote.
Unless there's some discussion, we'll take a vote on the ought to pass as amended recommendation. Representative Rice. Clerk?
An ought to pass is amended on House Bill 360 with amendment 0513H. Representative McLean.
Yes.
Representative Sylvia.
If that was me, yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Rice.
Yes.
Representative Steve Smith.
Yes.
Representative Green,
Yes.
Representative Kelly,
Yes.
Representative Tosh,
Yes.
Representative Troyer,
Yes.
Representative Marjorie Smith,
Yes?
Representative Birch,
Yes.
Representative Horsley,
Yes.
Representative Di Lorenzo,
Yes.
Representative Chase,
Yes.
Representative Kenny,
Yes.
Representative Langley,
Yes.
Representative Macbeth,
Yes.
Representative Page,
Yes.
Representative Simpson,
Yes.
Mr. Chairman,
Yes.
21-0.
Adopted the recommendation of not to pass as amended and without objection, put it on the consent calendar.
Mr. Chairman, Mr. Chairman,
Yes.
I apologize. I have to leave. I have a family emergency. I've got to go.
Okay. I'm so sorry to hear that.
I'm so sorry.
Okay.
Thank you.
Thank you. Okay. We're going to, we'll proceed with our executive session today, but I'm going to be sensitive to the fact that we have a member missing, and we'll deal with that as best as I think we can, okay? Next is House Bill 368, an act relative to claims for medical monitoring. Lane, do you have a motion?
Yeah, thank you, Mr. Chair. I move ought to pass on HB 368 and offer amendment 0494H, which I think I'm out to everybody on the committee.
Is there a second to that?
Second that.
Representative Chase seconds the motion. You want to address your amendment?
Okay, yeah, I think with the amendment, the reason I'm offering the amendment is in the public hearing, I asked Representative Cushing the question, which was, since the governor had vetoed this in the last session, what really was different? And his response was, there's a higher level of urgency, but really, I think that the governor did raise some concerns. But I think what we have to understand is that the genie is really out of the bottle with respect to medical monitoring. Courts are starting to recognize that we had the Hermans versus TCI case in Hillsborough Superior Court, which authorized certified a class action, and versus St. Gobain's Federal District Court there certified for medical monitoring. So the question really is, are we going to leave all this to the courts, or are we as the legislature going to be a voice in that discussion and show some leadership in that discussion? So if we can be practical, the governor vetoed it last time around. What this amendment does is it looks at a Vermont amendment that the governor of Vermont, who also vetoed medical monitoring legislation in Vermont, said he would support medical monitoring legislation if there was an amendment that clarified the nature of the harm. And so what this amendment does is it incorporates that by adding one term, and that one term, if you read it, is the plaintiff now suffers from a significantly increased risk. So just the addition of that one term, significantly increased risk, that actually adds a lot of clarity. And the reason that it adds clarity is because the term significantly is a statistically universally accepted term. So I think it really takes a lot of the fuzziness out of it. Any statistician anywhere in the world, when they do hypothesis testing, understands what a significantly increased risk is. There's hard statistical rules around that. And this is the language that the Vermont governor said if it was incorporated, he would support that kind of medical monitoring legislation. So my hope is by doing this, we can go back to the House, we can go back to the governor, and we can say, this is the change that we've made, and this is why you should rethink your position on the detail. So that's the nature of the amendment, and I hope you support it.
Any other discussion? Yes, Representative Chase.
I just want to agree with Representative McLean. We've done a really lot of hard work on this, looked at it from every angle. I like the amendment, and I would hope that we can vote to pass with the amendment.
Yeah, anyone else? Seeing none, Mr. Clerk, this will be a vote on the amendment. This is Amendment 2021-0494H. And Mr. Clerk, if you call the roll.
On adopting Amendment 0494H, House Bill 368, Representative McLean,
Yes.
Representative Sylvia,
No.
clerk votes yes.
5 minutes.
Senator Alexander.
No.
Representative Smith.
No.
Representative Green.
No.
Representative Kelly.
No.
Representative Toss.
No.
Representative Fryer.
No.
Representative Smith. Am I reading?
Yes, yes,
Representative Birch.
Yes.
Representative Horgan.
Yes.
Representative DiLorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman.
No.
That's 12 in the affirmative, 8 in the negative, and the amendment is adopted.
You've adopted the amendment. We're back to the motion, ought to pass as amended. Unless there's further discussion, I'll call upon the clerk to call the roll.
Just one thing, Mr. Chairman, if I could.
Yep.
I think on this, there was a strong case made that essentially you're tapping into a limited pool of money, and additional monies that are spent on medical monitoring for people who don't necessarily need it takes away from those who are in need. So I will be voting against this.
Yep.
So, Mr. Chairman, I will also be voting against this bill. I just don't think we should be enacting this into law. I don't think that we need to create this new situation.
Okay. Yes, Representative Chase.
Thank you, Mr. Chair, and thank you, committee. I just want to say I also heard that about having depleted funds and businesses going out. This with the amendment, the way I read it and the work that we've been doing, this is showing if somebody is showing suffering now significantly from an increased risk of an illness. It's not just for anybody who thinks that they've been exposed, but bringing that up to your doctor that you have been exposed at some time or you feel you have, well, just keep that in the records and also give it the opportunity that if something does start to come up, that it can look back to be related to what had happened within the water system or the ground. I don't feel that this is just people signing up, raising their hands, saying, I think I was exposed, I need you to now monitor me. This is a lot of care. There's been a lot of people that have been hurt from this, and we're going to find there are a lot more. I urge you please to pass with amendment.
And Representative Horgan.
Oh, thank you very much. Well, this is I view this same comment about the earlier bill about the PFAS. That this is hopefully when this works right, it's a preventive measure. So the medical monitoring can, first of all, put people's minds at ease if they're don't have any disease of exposure, but also it will they'll detect the disease and treat it sooner. So that'll save a lot of suffering. And also, I believe the asbestos cases came up with Johns Manville. It's just a full disclosure. My late father was a member of the class, which had many millions of people for the asbestos, and certainly, the amount of money we got was minimal compared to the amount of suffering he had, and he was vastly more fortunate than a lot of other people. So this you don't want to. So I think any type of suffering we can prevent, that's good. And I think I don't think the cost of this is excessive, unless of course they detect the disease and then that's a whole other issue. But anyways, I think this is a good bill. Thanks.
Any other discussion? Seeing none, Mr. Clerk, would you call the roll? This is on a motion of ought to pass with the amendment.
House Bill 368, ought to pass with amendment 04948. Representative McLean.
Yes.
Representative Sylvia.
No.
Clerk votes no. Representative Alexander.
No.
Representative Smith. C. Smith.
No.
Representative Green.
No.
Representative Kelly.
No.
Representative Tosh.
No.
Representative Tosh.
No.
Here. Representative Trotter.
No.
Representative Marjorie Smith.
Yes.
Representative Birch.
Yes.
Representative Horgan.
Well, I'm voting yes, and also and I don't feel the personal interest that I disclosed earlier, which probably others can share. I don't think that rises to the level of a conflict of interest that I'm going to vote yes.
Representative Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Chairman.
No.
That is 11 in the affirmative, 9 in the negative.
Can you give that number again?
Here.
11 in the affirmative, 9 in the negative.
Thank you.
You adopted the motion of ought to pass as amended. And Representative Wolfer, are you going to do a minority report?
I am.
Okay. Custom 384, an act prohibiting the sharing of location data. Representative Smith, would you like to make a motion?
Yes, I would move ought to pass, Mr. Chair.
And is there a second to that?
Second. Sylvia.
Who was that? Sylvia?
Yes, sir.
Okay, and would you like to address your motion?
Thank you very much, Mr. Chair. Yes, I would address my motion. This bill has to do with prohibiting the sharing of location data. I have long been and continue to be an advocate for privacy. I think that that personal privacy is an important component of how we can live our free lives in this country. I believe very strongly that this should be a matter addressed competently and intelligently on the federal level. In fact, it would be most effective if this was a national policy. But one of the great benefits that we have from our form of government is that many sound ideas were tried out first in states. And when then people in various states were able to see that it does work and it makes sense, that has moved our federal officials to find the courage and the knowledge to take appropriate action. And so while I don't think that the ideal answer is to have this handled on a state-by-state basis, the journey of 1,000 miles begins with one step, and I believe this is a solid first step for this state to take in protecting in an appropriate, responsible way, protecting personal privacy. Thank you.
Representative Alexander.
Thank you, Mr. Chair. While I am sympathetic to Representative Smith's points, I am going to oppose this bill. I do believe it needs to be a national policy, and that's why I recommend Representative Smith reached out to her congressman so we can get this rolling. I believe having federal or worldwide companies rewrite policies for one out of 50 states is not really a productive way of doing things. I think that there was a problem with sharing of aggregate data by companies so they can perform the best way possible in big cities. And I think this really adversely affects the gig economy. We should be pursuing avenues that allow the gig economy to grow. And I think location data helps them really figure out where their customers are and where they're moving. So I just think in general that this is a bad bill that hurts innovation in the gig economy and doesn't support our law enforcement. Thank you.
You have an amendment, Representative Wolper.
So, yes, I have an amendment. But I'd like to speak to the point that Arden made just for a moment. So, there's nothing that stops a company like Uber or any of these other gig economies for whom my son makes his living from using the data that they acquire for their own purposes or to satisfy requests from the individual or other services that they might desire as long as they request it, or, and there's broad exemptions for law enforcement, for emergency situations, for all those types of things. Those are exempted out of this bill. This is about these companies taking your personal data, and we had testimony during the hearing that a gentleman who was the actual driver of this bill brought it to our attention 2 years ago. In 15 minutes, putting in his own phone number, could find out enormous amounts of information about himself and where he'd been and things that he had done. This is not right. This should be stopped. If we can only do New Hampshire, then we just do it in New Hampshire. So that's that. The amendment that I offer is Amendment 0155H, and what it does, it replaces the applicability paragraph. And the big difference between the bill this year and last year is that last year we talked about web providers. This year we're talking about developers, a much broader spectrum of people to whom this would apply. And somehow there's some language gets snuck into that paragraph about where the information was acquired. It was a bad thing, so I reverted to the language we used last year, which was very well accepted by this committee, to make it clear that we're just talking about the information and the deposition, not exactly where it was required. So that's what 0155H does. So, and I would like to amend the motion to adopt Amendment 155H.
Okay, so we have an amendment that's been offered by Representative Wolper.
Mr. Speaker, I would be happy to remove my motion of just ought to pass if it makes things neater from the point of view of process. And if the seconder agrees, I would then move OTPA.
With Representative Wolper's amendment.
Yes.
I second that.
You agree with that, Representative Sylvia?
Yes.
Representative Sylvia is in agreement. So we're actually looking at a motion of ought to pass with amendment. And that's amendment 0155H.
But we need to do 2 votes.
Right, we'll do 2 votes. But Representative Birch, did you have comment?
Yes, it's more directed towards the overall bill, which regretfully I will not be able to support. I think it's, number one, it's too broad. And one of the areas where I think it's too broad is it makes no effective division between the collection of anonymous data and non-anonymous data. And I know, for instance, and that's a big difference. They're used for different purposes, and others, if we want to go state by state, which is a bad way of doing it, at least we should take a look at what other states have found not to be a good idea. And California found that lumping together anonymous collection and non-anonymous collection was a bad idea, and they separated it into 2 different areas. I'm concerned that this bill is so broad, it may affect the ability of my credit card company or whatever, or Amazon, to call me and say, there's a purchase made in Monaco of $4,000 worth of handbags. Are you sure you did that? And at which point I would probably say, no, I didn't. It's easy just to say privacy, 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 but we still need to have legislation that's clear, concise, and avoids collateral consequences that we may not like.
Thank you. Representative Smith, did you wish to speak again?
I don't think so. Thank you.
Representative Horgan?
I'm sorry, my hand was up. I didn't realize.
Thank you very much, Mr. Chair. I mean, I think this bill is too broad, and it's a federal issue, and also it doesn't address the problem what happens when somebody, there's lots of things we do in the web where your location is part of the point of it, like say when you post pictures of yourself on Facebook, or I guess it doesn't exist anymore, but Parler or whatever, which so lots of times you advertise you're at a location deliberately, or maybe the integral part of the service, and then you have regrets later. So that's not really the social media site's fault, but it does seem like there's a lot of, so it does seem like people often, like, if you're trying to get people from getting in trouble because somebody knows where they are, a lot of times it's because you deliberately advertise where you are, but then somebody else who's using the service doesn't like the fact that you were there. So that's I think this bill, that's just one of a multitude of problems with this bill. So I think it's not ready to pass. So it should be ITL. Thanks.
Representative Wolper?
Thank you, Mr. Chairman. And I'd just like to respond to this as far as the disaggregated data that's not attached to you. I can't imagine how that would be a problem. And if you publicly share your location, then that makes that public, and it's no longer subject to a privacy interest. So I don't see why that would be a problem. So I don't see those as impediments to this bill.
Any other discussion? If not, we'll be voting on the amendment first, and that's Amendment 0155H. And with regard to the adoption of that amendment, and Representative Wolper, Mr. Clerk, would you call the roll on that?
On adopting amendment 0155H to House Bill 384, Representative McLean,
Yes.
Representative Sylvia,
Yes.
Representative Court votes yes. Representative Alexander.
No.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
Yes.
Representative Burke.
No.
Oregon.
Red Oregon votes no in the amendment.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chair,
Yes.
you have to vote 17-3 in the affirmative.
Other discussion, we now have adopted amendment 0155H. Back to the motion of to pass as amended. And Mr. Clerk, seeing no hands up, if you want to call the roll on House Bill 384 on the motion of recommending to pass as amended.
On House Bill 384, amended by 0155H. Up to pass. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
No.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
Yes.
Representative Burke.
No.
Representative Horgan.
No.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
No.
I voted 16 yeas and 4 nays.
Anybody have any objection to putting that on the consent calendar?
Yes. Yes, I think we'll probably might get pulled off the consent calendar anyway, but I'll put in the regular calendar.
Is it your intention to do a minority report, Representative Horgan?
I haven't decided yet, so no.
Yes.
Yeah, is that a maybe or let's,
Maybe, yeah.
when will you have an answer to that?
Oh, okay. Well, I'll have an answer today. I'll probably, yes. Okay, I'll change my maybe to yes. I'll write up a report today. Thank you.
Mr. Chair,
Yes.
although I made the motion, the prime sponsor is a member of the committee, that is Representative Welper, and I would like to ask if he would like to write the committee report for the calendar.
Yes.
Okay.
Thank you.
Okay. I'd like to do, there's no objection, is because we don't have the full committee right now, is I would like to skip over House Bill 440. I know that that would be important to Representative Rice, and wait and see whether or not she's able to join us this afternoon, if that's okay with everybody.
Absolutely.
Okay, the next bill would be HB 453, an act for mandatory disclosure of sources by subpoena. Is there on that? Representative Alexander?
Thank you, Mr. Chair. I want to move HB 453 and expedient to legislate.
Is there a second to that?
I second that.
And you want to address that?
Yes, Mr. Chair. I really think there's a lack of definition on what a journalist is. I think it's kind of a broad bill, and I think that freedom of speech or freedom of the press is very important. And I think that I don't think there's a clear definition on journalism in this, so I think it's.
Is there any other discussion on the motion? If not, Mr. Clerk, I think you can call the roll. This is on a motion on House Bill 453 of inexpedient to legislate.
House Bill 453, inexpedient to legislate. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes no. Representative Alexander.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
Yes.
Representative Burke.
Yes.
Representative Horgan.
Yes.
Representative D'Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
No.
Representative Langley.
Yes.
Representative McCut.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
as far as 18 in the affirmative, 2 in the negative.
You've adopted the recommendation of inexpedient to legislate by a vote of 18 to 2. Is there any objection to having that on the consent calendar? Seeing none. It's on the consent calendar. House Bill 474. An act prohibiting surveillance by the state on public ways or sidewalks. Representative Sylvia, if you want to make a motion.
Yes, as soon as I can get.
You're muted.
Gee, I got caught there, didn't I? I would move ought to pass, and I believe I have an amendment to offer.
So Representative Sylvia has moved ought to pass and is going to offer an amendment. Is there anyone to second that?
I would second it.
I saw Representative Simpson's hand. Simpson's
Fine.
You know the amendment number, sir?
Yeah. Do you have the amendment number, Mike?
Yes, 0461H.
And you want to address that?
I'd love to, but I've reached the end of my preparation, and I'll have to do a little bit of scrambling. If anyone wants to help, by all means, jump in.
The amendment is, Mr. Chair,
Yes.
the amendment is relatively short. Would it help you, Representative Sylvia, if I read the amendment?
Yeah, sure.
Mr. Chair, would that be?
That would be great.
Okay. Amend the bill by replacing all after section 2 with the following. 3, new subparagraph, highway surveillance prohibited. Amend RSA 236-133 by inserting after subparagraph G the following new subparagraph. H, is undertaken for security and to facilitate law enforcement in the investigation of criminal activity at properties under the jurisdiction of the Department of Natural and Cultural Resources, provided that no video recording shall be stored longer than 24 days, except if needed in a judicial or administrative proceeding in a particular case. The properties on which surveillance occurs shall display signage indicating the presence of 24-hour video cameras. Effective date, this shall take effect upon its passage.
Thank you.
It's great to have professionals with us.
So do you have any further comment, Representative Sylvia?
I do not.
0461H. Any other comments on the bill or the amendment? Are you ready to vote? It's
Yeah, this is requested by the Department of Cultural Resources because they have situations and so, and they don't really deal with the public ways the way we normally think of them. So it's a friendly amendment.
Well,
0461.
0461.
I'm adopting amendment to House Bill 0461 to House Bill 474. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Upton.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Troyer.
No.
Representative Marjorie Smith.
Yes.
Representative Burke.
Yes.
Representative Holden. Representative Horrigan.
No, sorry, no.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny. Representative Kenny.
Don't see him.
Mr. Clerk, he messaged me, he has to restart.
We lost him, I think.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman.
Yes.
I vote at 17-2.
Before we begin this vote, just want to make sure Representative Kenny be available.
Let me see what's happening. Wait a minute. The chair is waiting for your vote, Pam.
Well, depends on you, Cam.
Come up here and vote on my screen.
You had to remove.
Okay. Mr. Chair, if you could wait a moment, Representative Kenny has lost his coverage, but he is going to come and show his face on my screen so he can vote. Is that okay?
Great.
Sure.
Thank you. Turn right. Yes.
Hi, committee. Sorry about that. Yes. And I should be back on mine in like 2 to 3 minutes. Sorry again.
Famous last words.
We'll do one more bill after this, and then we'll break for lunch.
It's like a plan.
Mr. Chair, I apologize, but with that interruption, I didn't get the final vote on the amendment.
18-2.
Thank you very much.
You've adopted the amendment. We will vote on the bill ought to pass as amended as soon as Representative Kenny gets back online.
He could come up and do this again, so don't delay for him.
Okay, well then, thank you. This is House Bill 474. Unless any further discussion. I see your hand up, Representative Sylvia. Is that for a reason? No? If you're not looking to speak, then Mr. Clerk, why don't you call the roll on House Bill 474? This is on the motion of ought to pass as amended.
House Bill 474 ought to pass with amendment on 461. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Representative Walter votes yes. Representative Alexander.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
No.
Representative Marjorie Smith.
Yes.
Representative Clark.
No.
Representative Holthagen.
No.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
I vote is 17 in the affirmative, 3 in the negative.
So you've adopted the recommendation of ought to pass as amended by a vote of 17-3. And I said it earlier, we will do consent. Yeah, does anybody have an objection to the consent calendar? Seeing none? Without objection, will be on the consent calendar. Okay, we'll do House Bill 540. And then what we'll do is plan to break for lunch after that. So we do have House Bill 540. This is an act relative to supportive decision-making, and it's an alternative to guardianship. Representative Chase, did you want to make a motion?
I do. I'd like to make a motion to pass with amendment. And I would like to refer to the amendment that you should have received shortly ago. It is 0565H. May I speak to the amendment?
And is there a second to
Oh, I'm sorry.
that motion? Who would be seconding? Representative Simpson. Okay, go ahead, Representative Chase.
All right, I want to speak to the amendment, and again, that is 0565H. There was a little bit of concern with the statement of findings and relative to what a disability is. We talked about this quite a bit. I did agree with that, yet I didn't find that it had a lot to do with the body of the bill, but it was not needed. So that has been removed. And also, there were a couple of other amendments that came through that have been incorporated into this, and those are in regards to the IEP team and what they would do with a student or family. The team shall inform the student and the family of the ability to support decision-making in pursuant to RSA 464-D as an alternative to guardianship. It should be done promptly when guardianship is first discussed. The team shall make available resources and assist in establishing a support decision-making agreement. If that is executed, the IEP team shall abide by the decisions made by the student pursuant to the reported decision-making agreement. And basically that's it. We just tried to clear up what possibly was considered, and I'd hate to use this, but offensive, and I agree, language about the definition of disabled in the subject statement of findings. And the rest is just the work that's been done with the stakeholders and task force group that has been working on this. So I would urge you to vote for the amendment and then ought to pass on the bill.
Representative Sylvia?
Thank you, Mr. Chairman. I'm basically sort of supportive of the bill. I'm not leaning either particular way. I was certainly concerned with the unconscious bias that made its way into the findings originally. And having only had a little while and essentially reading the amendment while we're doing this and falling behind on my other work, for which I apologize. I would like more time to consider this. So I don't feel like I'm prepared to vote for this at this time. So I will not.
May I ask a question?
Just hold on. I'm going to call upon Representative Macbeth first, and I'll come back to you, Representative Chase.
I apologize to the committee. I just hadn't lowered my hand. Thank you. I support this amendment, but I didn't raise my hand.
Representative McLean?
Yeah, I just want to echo Representative Sylvia's comments. You know, while I'm broadly supportive of this, I'm just getting the amendment at 10 o'clock, and so I'm just looking at it now. I haven't really had time to process it. So in light of that, if we could maybe hold off a little bit, I would like to do that.
I could just ask Representative Sylvia, are you, when you say to put off making a determination on it, are you talking about maybe putting it off till next Wednesday, or are you talking about retaining it until next week?
Well, yeah, I'm not, as you've seen, I'm not a fan of the retention. Perhaps by next Wednesday, we could have some input from folks, you know, with disabilities, because obviously they are more sensitive to the language than certainly I would be. I'm, you know, more or less pretty whole, although, you know, I have my defects. So next Wednesday would be fine by me.
Would that be okay with you, Representative Chase?
I do not have a problem with that at all. And I am also willing to remove the statement of findings completely if that is still a question to people after they read the amendment and still don't feel comfortable with it.
Representative Smith? You're muted.
Imagine that. Usually I'm not muted. If Representative Chase and Representative Simpson would pull back their motion with respect for them and for Representative Sylvia's comments, I don't think any of us have had a chance to really reflect in detail on this amendment. And I would hope that the chair would agree that we add it to next Wednesday's calendar, and that would give people a time to look at the amendment and consider any further changes that they might want to suggest.
I'm good with that.
Representative McBeth?
I support that. What?
It's okay. So I certainly have no objection. I'm presuming that Representative Chase and Representative Simpson, you'd withdraw your immediate motions at this point in time.
So I will withdraw my motion.
And I withdraw my second.
We'll plan to address House Bill 540 at our session a week from this Wednesday. It will be our last executive session of House bills.
Okay.
Okay, so why don't we break for lunch and come back at 1 o'clock? You guys have just done great going through these bills today. Terrific. So thank you so much, everybody. We'll see you at 1 o'clock.
Thank you, Mr. Chair.
See you in a bit.
Thank you.
What time is it we're coming back? Oh, 1, okay.
unmuted.
Hello, everyone. We're back from recess. And so I'll call to order this meeting of the House Judiciary Committee. By my count, we have 8 more bills to address this afternoon. The issue that I'm faced with is that we have several of these bills, which I know, and I've tried to reach out to Representative Rice, but I have not heard back from her and don't actually know what her circumstances are. I know some of the bills are going to be bills where we're going to have, I think, based upon my count, we're going to have some very, very close votes, and her vote may very well make a difference on the outcome of those recommendations that we make. And so I'm somewhat reluctant to go forward on those bills where I think her vote would make a substantial difference, and might want to, if we're able to on those particular bills, consider continuing them or recessing them and hearing them next Wednesday with the remainder of our bills. But we do have some bills which I think we can take care of today, should take care of today.
We have some hands.
Yeah. Representative Horgan.
Yes, for planning purposes, the meeting we're having on Friday, I mean, it does have the usual notice about executive sessions may be met, but your anticipation is that will be purely a day for hearings?
The only thing that's scheduled right now is hearings, but we are capable of having executive session. I've tried to be very careful with the executive sessions so that I make sure that everybody is available and incorporate them. In the last few hearings we've had, we haven't necessarily had everybody available to do an executive session, so I haven't been having them. But the fact is that we could do executive session on some bills if we elected to do so on Friday.
Yeah, fair enough. The reason I ask for planning purposes, I have something scheduled at 3, and I could reschedule it with enough advance notice, but I'll play it by ear. So thanks.
No, I'm trying to be as inclusive as everybody for everybody, and that's why I've sort of scheduled these separate days for the executive session so people could plan for sure to be there or find a substitute.
Thanks.
And Representative Kenny.
Thank you, Mr. Chairman. Just for the record, my power is back, so I've returned back to my own apartment. I am here. Roommates are in the apartment and may be throughout the room for the rest of exec. Thank you.
Thank you. And Representative Smith.
Thank you. I guess I should say that my solitary confinement, which was interrupted for a few hours this morning, is now back, and I'm alone again. And it was very nice to have someone a floor away. But I do want to say that I thank you very much for the care that you have demonstrated in announcing in advance when you were going to exec. I think that's best for the committee and it's best for the public. And the current schedule for next Wednesday isn't exhausting, certainly the way this one could have been. So as I look at the afternoon, I see 3 bills that I can identify where I'm pretty sure the sense of the committee will be, if not completely unanimous, be significantly so. And perhaps we could go ahead with those, and then you still would have time to put in the calendar an amended notice for next Wednesday, to which you could add all of the bills that we would like to defer until then. And I would encourage that because I think that's best for public notice and for the committee planning. Thank you.
Thank you. With that, that's I think, exactly what I would like to do. And if I'm not in it, if I don't have the same 3 bills, Representative Smith, you let me know. But I think the next bill I'd call would be House Bill 569. Senator Macbeth, would you like to make a motion on that?
Yes, thank you, Mr. Chair. I would. I move that this bill, ITL, and I'd like to speak on my motion if there's a second.
Yeah, if there's a second for that. By Representative Alexander. Yes, go ahead and speak.
Thank you, Mr. Chair. So I think that the representative that brought this bill really shows what, the citizen legislature is all about. A constituent had come to him with a concern, and he's brought the bill to the legislature. He's had a full hearing. He was able to speak with the Chief Justice of the Superior Court and, the representatives from the Administrative Court and the Drug Court. I think that all those stakeholders really heard the concerns that his constituent had. And, while I'm ITLing the bill, I do think that he served his constituent well. And I felt that the concerns about the drug court and this need for the other vocational help, I think that the stakeholders answered that well, but again, I think that it's heightened their sensitivity to the need for that. So I do move to ITL it. Thank you.
Any other discussion? This is on House Bill 569 and on the motion of inexpedient to legislate. Seeing none, I'll call upon the clerk to call the roll. Again, this is on the motion of ITL.
House Bill 569, inexpedient to legislate. Representative McLean.
Yes.
Representative Sutton.
Yes.
Clerk votes yes. Representative King.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
Yes.
Representative Burke.
Yes.
Representative Horgan.
Yes.
Representative Di Lorenzo.
Yes.
Representative Chase.
Yes.
Representative Kane.
Yes.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman.
Yes.
Vote 20-0.
No objection to the consent calendar?
Nope.
I think the next bill that I think we can work on would be House Bill 584. relative to guilt defamation by media outlets. Is there a motion? So,
Mr. Chair,
you,
I'd like to make a motion of ITL.
and is that seconded? Seconded by Representative Birch. And would you like to address that, Representative Di Lorenzo?
Yes. It appears that this bill is not needed, and it could possibly be in violation of the U.S. Constitution and the New Hampshire Constitution. I know that members of the press are opposed to the bill. And that's about all I have to say. Thank you.
Any other discussion on House Bill 584?
Yes, I think maybe when the bill was written, they also underestimated the ability of media consumers to know that old stories are old stories, and there's probably a newer story from things have happened since then too. Like I know I was on the front page of a union leader for doing something stupid about 10 years ago, and actually pretty rare that anybody brings it up, but when they do, I know I've done lots of other things, lots of other stupid things, and occasionally some not so stupid things since then. I think that's the case for most individuals who have old stories about themselves in the newspaper. And also, of course, we want the media to report more news, not less. So I would, and I of course I agree it's totally unconstitutional as well. So that's just.
Any other discussion? Seeing none, this is on a motion of expedient to legislate on House Bill 584. And Mr. Clerk, would you call the roll?
House Bill 584, expedient to legislate. Representative McLean.
Yes.
Representative Sylvia.
Yes.
Clerk votes yes. Representative Alexander.
Yes.
Representative Steve Smith.
Yes.
Representative Green.
Yes.
Representative Kelly.
Yes.
Representative Tosh.
Yes.
Representative Trotter.
Yes.
Representative Marjorie Smith.
Yes.
Representative Birch.
Yes.
Representative Horgan.
Yes.
Representative Di Lorenzo.
Yes.
Representative Chase. Representative Chase.
You're muted.
Yes. Sorry, I thought it was it. Yes, yes, yes.
Representative Chase.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman,
Yes.
it's a 20-0 vote.
Okay, the vote being 20-0, we have adopted the recommendation of ITL 584. And we'll put that on the consent calendar unless there's some objection. Yes, Representative Smith.
No, I'm just getting ready.
The next bill I think that we can address is HCR 3. And now, are you ready, Representative Smith?
Thank you very much. Yes, Mr. Chair, I would like to move ITL on HCR 3.
Is there a second? Who would like to second that? Representative Birch. Would you like to address your motion?
Yes, thank you very much, Mr. Chair. I don't think there is anyone on this committee who does not believe that the way we educate our children in a democratic society, that's a small d democratic society, is essential to our social, cultural, economic survival. And I don't think there is anyone in this committee, if certainly speaking for myself, who does not believe that we haven't necessarily found the absolute best way to provide appropriate educational opportunities for every citizen of this state, really from birth until death. And we recognize the complexity. So I have great sympathy for Representative Lewicki for raising this issue, and do not want to say anything in any way to minimize the importance of the issue that he raises. But I believe very strongly that the reason we are called representatives is because we represent all of the people in the state. And more than any other state, each of us represents a smaller number of people, and therefore are, at least in theory, closer to the people we represent. It is because of that that I believe it is important that it is the legislative body that focuses on how to shape access to and funding for quality public education for all. The courts have acknowledged that again and again in saying that it is the responsibility of the legislature to do that. But they have done it within the context of the Constitution, which lays out the underlying constitutional obligation for a free and appropriate education for everyone, so that the court is saying to us in the legislature, do your duty. And I think that is appropriate. And I think it's appropriate for us to do our duty and to develop the legislation that could make us all proud of the public education we have in this state. I do not think that a House concurrent resolution accomplishes any of that. I think it is conceivable a constitutional amendment might be the answer. It is conceivable that additional legislation might be the answer, but a House concurrent resolution does nothing to achieve our shared goals. And so, with respect for the sponsor, and inviting you to take an opportunity in your free time to read the excellent material that former Republican Representative Doug Hall shared with all of us, I hope you would join with me in voting ITL on this House concurrent resolution. Thank you, Mr. Chair.
Thank you. Representative Horgan.
Oh, thank you very much, Mr. Chair. I'd just like to add, and as my fellow rep from Durham knows, because she has served as the chair of the Finance Committee, we've actually passed many laws related since the Claremont decisions about educational funding. None of them have been a entirely satisfactory definitive answer, but we actually, the law that educational funding is, there is law about educational funding, so our adequacy formula, the rest of it, that actually, does exist in law. And then in a few weeks, we'll be considering a bill which will probably make changes to that law. So like the whole basic premise of the HCR is at least somewhat factually incorrect, in my opinion. So that's all I had to add to it. So like certainly, I think Representative Smith said pretty much said it all, in my opinion. So
Thank you. Representative Alexander?
Thank you, Mr. Chair. I do agree with Representative Smith insofar as an HCR does not provide the solution to a problem that the state has been dealing with for a while. I believe that, education for all is very important, whether parental choice, or, saying it's the public or public charter schools, et cetera. But there's other avenues to deal with this issue, including addressing it through a CACR, further actions to the court through different cases. And I just believe that there is a separation of powers, and when the court makes a decision, an HCR to combat that isn't necessarily the right move. The move would be to introduce the CACR. So I'll be voting ITL, although I do sympathize with the motives of the author of this case.
Representative Smith?
Oh, I'm sorry, Mr. Chair, I just didn't lower my hand.
Okay, thank you.
Now I've lowered it.
Representative Wolford?
So for me, it wasn't as much about education as it is about the inherent powers of the various branches of the government. The argument that we have to do a constitutional amendment when the Supreme Court makes decisions that are egregiously wrong, to me is egregiously wrong. We, as an independent branch of government, have our own responsibilities to read and follow the Constitution. I believe this HGR makes that clear. And despite the fact that the Claremont decision was reached many years ago, we've never complied with it, and I don't know that we ever will. But beyond that, I read Doug Hall's testimony. Read every word. When I get all done, I thought he was for the HCR, because in nowhere in any of what he wrote did he any time in our history when the state had provided funding or assumed any responsibility other than to tell the local municipalities they had to raise some amount of money. And I don't believe that the court has the authority, even under the Constitution, to put the legislature in a position where it must do things that it doesn't want, that might raise money. So I'm supporting the HCR, and that's why.
Any other comments? I guess if I could just add, saying from somebody that actually was part of the other brigade at some point in time, I can agree with many findings that are in this bill. And getting back to the issue of whether you can interpret the word cherish at the meaning of the word cherish to require the state that requires the state to make financial payments or support. And frankly, I always felt from the very beginning that was a stretch on the part of the court. I think even if I agree with all the findings, it's the conclusion that's really the problem. And that is that the findings of the court just aren't binding at all on the legislature. And that's contrary to the very way we've operated the country for 200 years. From Marbury versus Madison, going back to when the founding fathers were still alive and accepted that as the manner in which we would run our government. And to now say we as a legislature just aren't going to accept that, I find that anathema. I find it hard to accept. It seems contrary to everything that we learned in our civics class from the very first day we went to school. So I have a hard time with HCR 3. Is there anybody else who'd like to comment?
Who was the second nominee?
Birch, Paul Birch. Okay, I guess we're ready to vote. This is on the motion of inexpedient to legislate.
HCR 3, inexpedient to legislate. Representative McLean.
No.
Representative Sylvia.
No.
Clerk votes no. Representative Alexander.
Yes.
Representative Steve Smith.
No.
Representative Green.
No.
Representative Kelly.
No.
Representative Toss.
No.
Representative Trotter.
No.
Representative Marjorie Smith.
Yes.
Representative Burke.
Yes.
Representative Horgan.
Horgan votes yes.
Representative Dorito.
Yes.
Representative Chase. Representative Chase.
Yes.
Representative Kenny.
Yes.
Representative Langley.
Yes.
Representative Macbeth.
Yes.
Representative Page.
Yes.
Representative Simpson.
Yes.
Mr. Chairman.
Yes.
That voted 13 yeas, 30 nays.
You adopted the recommendation of inexpedient to legislate and be a minority report.
Well, I'm not sure who's right.
Okay, there are 5 bills that we haven't addressed today. Bill 550, 561, 566, 578, and 630. Those are the 5 bills which I think would have very close votes, and I'm sure Representative Rice would like to be here to vote on those bills. So we'll carry those over, and I'll make sure that they're noticed in the calendar for the 10th, which is a week from Wednesday. Is there any other?
Mr. Chair, you'll also carry over 540?
Yes, there were other bills that we addressed. It was 540, and there was one other earlier this morning.
Right. Is that 216?
It was 216, and those will be noticed in the calendar as well. There was another bill as well, and it's House Bill 232. And if you remember, in our very first executive session, we voted 10-10, and that not being very satisfying, we recessed the hearing on that. And I will notice that as well, so we can finally address that bill in our executive session on the 10th.
What about 440?
Did we retain that?
Yes.
Oh, that's retained?
No.
No, I thought
I have-
we were holding it for Representative Rice.
Yeah, we were holding that over, I thought.
Oh.
Yeah.
Yes, we're holding on to
Oh,
that.
that's right, of course.
So that will be noticed as well in the calendar. Okay, is there anything else, any other business? I'm going to just ask everybody who has made the motions and is going to be doing the committee reports, if they would get their committee reports to me tomorrow so I can work on them and get those committee reports out. And that goes for the majority report and the minority reports as well.
Like Hampton Hod, I actually have already sent in the minority report. I wrote it up at lunchtime and sent it in, so hopefully that'll be suitable.
Right. Email them to me.
On a report.
And since we're getting out early this afternoon, you have time this afternoon to do them. If there's no other business, then I'll call this meeting of the House Judiciary Committee to a close, and we'll adjourn until we meet on this Friday at 9 o'clock to hear the last of our bill, finally, the last of our bills for our House bills, I should say. And we'll see you Friday.
Thank you, Mr. Chair, and thank you, Mr. Clerk.
Bye.